Good morning and good afternoon. Welcome to the first webinar of the 2025 Estate Litigation Series. My name is Jonathan Lancaster. I'm a partner in the litigation department of Fasken's Toronto office. My practice focuses on corporate commercial litigation, real estate litigation, and then naturally to estates litigation, given the nature of estates these days, many estates these days. And over the years, I've worked on many estate-related litigation files, from will challenges to issues with the administration of estates and also professional negligence in the context of estates. Before starting, I'm going to introduce before introducing the fellow presenters, I'm just going to deal with some administrative issues, as you can see on the screen. Regarding the handout, the CPD certificates and disclaimer, and there's links and QR codes that will be available at the end of the seminar. There's closed captioning under the CC button. There's also a survey we'd ask you to complete. Questions, we have a number already, but please put any questions in the questions tab. We'll try to deal with those as well. And then there's the information on technical support. If you require support, please click the tech support button at the bottom of the video window page. Joining me today is Alex Kotkas. Alex is the managing partner of Fasken's Alberta region. He has primary responsibility for the leadership of the firm's Calgary and Sutina offices. Alex is the founder and former leader of the firm's litigation dispute resolution group in Calgary. He's a seasoned litigator with extensive trial and appellate experience, has appeared as litigation and arbitration counsel, and as an advocate before a variety of statutory boards and tribunals, and provides practical advice and outstanding advocacy in high-stakes arbitration and litigation. Eric Clavier is a partner in our Vancouver office, and Eric assists clients in a broad array of estates matters involving contentious issues relating to wills, trusts, undue influence, incapacity claims, committeeship applications, unjust enrichment claims, breach of fiduciary claims, abuse of power of attorney claims, breach of trust claims, passing of accounts disputes, to name a few of the many issues that arise under the rubric of estates litigation. Now, in terms of our presentation, I'm going to turn it over to Eric, who will get us going for today's discussion.
Thank you, John. So just as a broad overview as to what we're going to be talking about today, we're going to be focusing on some of the most common mistakes that might trigger litigation and what they are, how you can potentially work around them or avoid them as best as possible, and in particular, what kind of litigation would these mistakes potentially trigger, because the relevance to you today is to recognize and realize that even the best laid plans of mice and men sometimes end in disaster. So you may have all the best intentions in the world in making an estate plan. If you're not aware of some of the mistakes that we're going to identify for you today, it may result in litigation, which is in nobody's best interests, certainly not your estates, but not your family members and beneficiaries. And then we're going to end off with some questions at the end. So feel free to post some questions in the Q&A box, and we will try and get to as many of those as possible. So then, what are the top 5 litigation triggering mistakes? The first that I'm going to be speaking to is do-it-yourself wills. There is poor timing, incapacity, and undue influence, which Alex will speak to. Alex and I will both speak about the impact of unfair distribution schemes in your estate plan. And then we will continue with Alex looking at joint ownership planning, and wrong executor or trustee choices is something that I will speak to towards the end. And then we have some additional information that John is going to be speaking about in respect of pour over clauses. So with that having been said, then the first mistake that we identify is do-it-yourself wills. And I think as a starting off point, the takeaway should be that there is no such thing as a simple will. You may have heard that there are will kits available online, or you may have received a pro forma from somebody else in your family, or have seen a will that somebody else has made, maybe download something off the internet. and you think, well, my estate is pretty simple. I'm going to use this pro forma, this will kit. That can work, but you should know that one of the issues with wills is that they have very formal requirements under the statutes across various jurisdictions in Canada. And so as far as your will, codicils to a will or holograph wills are concerned, they must meet some legislation required stipulations, such as, for example, they need to be in writing, they need to be signed by the will maker in the presence of two witnesses who sign in the presence of each other and of the will maker. And if they don't comply with these statutory formalities, the will would be invalid on its face, and litigation inevitably may result in trying to cure that document. That's something you may not know if you're just using a pro forma. That's something that might lead to litigation if you are using, a will kit. The other questions that you may not be aware of is that there are residency requirements for personal representatives. What you don't want is the executor of your will to be someone who lives abroad, for example. You might not know that there are issues when the executor that you've chosen lives in a different jurisdiction. So I'm going to touch upon those briefly. And then, of course, you have an obligation at law to provide and maintain certain dependents. Who are they? What must you provide for them? How can you work around that if you do want to disinherit someone? You might not know any of these things, and that is one of the reasons why there is, we say, no such thing as a simple will. So some of the errors that you might make in this context is simply not providing for those that you must. You have legal and you have potentially moral obligations depending on your jurisdiction. And if you don't meet those obligations, there is inevitably going to be a lawsuit or some kind of will challenge that follows. If you fail to appoint an executor or suitable alternate executors, that too can result in you having prepared a will, not having realized a will needs an executor, and there being nobody to administer the estate without there being potentially a dispute as to who's going to actually be the executor of your will, because you haven't picked someone. You might not realize that you also should be picking an alternate executor, so that in the event that the person you've first picked is either incapable, predeceases you, or alternatively renounces and says they don't want to do it, who then is going to step into their shoes? One of the mistakes that is often made in people using wills kits is that they don't realize that they have the opportunity in the making of the will to appoint a guardian for their minor children. So that's very important. If you don't appoint a guardian for your minor children in your will, there is a risk that the province at the end of the day is going to be in charge of the minor children. And you can avoid that quite simply and quite effectively, simply by picking someone that you've spoken to, confirm that they're prepared to do the guardianship, and including that in your will. Other mistakes we often see is a failure to properly revoke earlier wills or codicils. What that results in potentially is having multiple wills, multiple testamentary instruments that are in conflict with each other. And where the earlier version hasn't been revoked, which version governs? They should be heard together or seen and read together. And how do you distribute in the event that your second or your third will that didn't properly revoke the earlier wills is entirely different from the prior ones? You can imagine that's going to result in someone going to court asking for clarification. Most people also might think that they are using clear and very logical language, but perhaps it is not as lacking in ambiguity or clarity as you may think. And so using ambiguous or unclear language is something that may result in an application to court for the executor of your will or the administrator of the estate to get clarity and obtain some sort of direction as to what the language used truly means. What are the litigation risks? I've spoken about applications. There are also the risks of trials. So it's a different process. A trial is something where viva voce evidence is led. You call witnesses like you might see on television. They get cross-examined. But applications are essentially motions to the court to determine issues, such as proving the formal will. If there is non-compliance with the formalities and the requirements of the will, then someone is going to have to apply to court to cure the will or to prove the will. But there are many different scenarios where that may become relevant, such as if there is a dispute about undue influence or whether or not the person was in fact legally capable of executing a will, that may result in an application or trial. If you have varying instructions or competing memoranda of wishes, there may be an application to court to validate those instructions and to get clarity as to how the estate should be administered and distributed. The often seen situation we have is applications or trials to interpret or construct the will. That's going back to the point of not using clear and unambiguous language, where the court is essentially being asked to interpret what it is that you or the will maker intended. There could be applications to vary the will if you fail to make adequate provision for those dependents to whom you have a duty to provide. And in some provinces, such as in British Columbia, and I'll touch upon that a little bit later, there might be an application or a trial to vary the will where an obvious beneficiary has been disinherited. So how do you minimize that litigation risk? How do you avoid it? Well, the first that I would recommend is that you consult with an estate planning lawyer. Meaning no disrespect to lawyers that don't practice in this space. Estate planning lawyers specialize in identifying, number one, what estate plan you need, how best to construct an estate plan that covers your intentions and your wishes, and to avoid the kinds of risks that we are speaking about here today. So that is the first thing. The second thing is ensure that you fairly distribute your assets as much as possible. I'll get back to that again a little bit later in the context of BC variations, but you should always consider, if you aren't making an equal division, to make a statutory declaration or a memorandum of reasons to explain yourself, so that once you're no longer around, the court can look at this document and see why you have made your will in the manner that you have. You should appoint the appropriate person to act as executor or personal representative. We're going to get to that a little bit later in today's presentation. Identify a guardian for your children. I've spoken to that. And then consider alternate planning options, because a will is but one of the tools in your toolbox when you're making an estate plan. You can also, when you're meeting with this lawyer, you'll be informed about trusts, joint ownership, as well as dual wills where you might own shares in private companies. So there are many different options available to you, which you don't necessarily know if you're using a pro forma of the internet.
Thanks, Eric. I will now, hi, I'm Alex Kotkas, as John indicated. I will now address mistake number 2 on our list, poor timing, incapacity, and undue influence. Just waiting for the slide to advance. Here we go. Okay, so to begin with, the concern about timing is primarily with respect to testamentary capacity. In order to be able to draw up a valid will, the person who makes the will, we call them the testator, must have testamentary capacity. They have to have a sound and disposing mind, is some of the terminology used in the case law over the years. So the person making the will has to understand what they're doing and the effect that it has, that it distributes their assets after death. They have to understand the extent of the property that they're disposing of. They have to understand what they own, effectively. They must be able to understand the claims to which they should have turn their mind. And they must not have any mental illness or disorder of the mind that, in the old terminology, poisons their affections, perverts their sense of right, or prevents the exercise of their natural faculties, meaning that if they were suffering from some kind of delusion, that might affect who they would give assets to in their will, and that would make them incapable of drawing up a will. And of course, if you wait until people get quite elderly, then you run the risk that somebody loses testamentary capacity and can no longer make a will. Of course, in that case, you're left with the statutory intestate structure that each jurisdiction in Canada has put in place. And that may be fine, and it may not be what you wish. So ideally, wills are done sooner rather than later. In terms of an example, we provided the W estate case out of Ontario. In that case, the testator left almost his entire estate to his second wife, except for a small amount to two of his three sons from his first marriage. Now, this fellow suffered from Parkinson's and Lewy body dementia. The outcome of the case was that capacity was not proven. And the reasons include that in the course of the trial, it became apparent that there had been a lawyer advise that capacity assessment was required. So this being an assessment by a doctor to indicate whether the testator had capacity or not. And that capacity assessment was not obtained. And then the dementia that the person suffered from really prevented them from really appreciating their overall financial position, what their assets were, and affected their feelings with respect to their sons from the first marriage. Obviously, the nature of the document itself can affect whether it seems a person had capacity or not. And in this case, the will was convoluted and out of character for the person. And their higher functions were affected by the dementia from which they suffered. Turning now to undue influence, in this case, we're talking about somebody effectively being bullied into making a particular form of will or giving a particular gift in the will with respect to their estate. And bullying alone is not the full legal definition, of course. But the law does invalidate a will when undue influence is proven. It's a difficult case to make out, but not impossible. Effectively, the persons, to make out the case, you have to demonstrate that the person making the will was coerced into it and effectively overpowered their own independent judgment and wishes. And so it is sometimes described in the case law as an influence which can justly be described by a person looking at the matter judicially to have caused the execution of a paper pretending to express their intentions, but really does not do so. And that's effectively what it is. We're trying to get to what the intention of the person was, not what they were bullied or coerced into doing. Back to the W estate case. In that case, the court also found that both the will and an earlier property transfer made during the life of the testator were influenced unduly by the second wife. The evidence was that she disliked the sons from the first marriage, that she disregarded the first lawyer's advice about a capacity assessment and went to another lawyer, that she had persuaded her husband to transfer much of his wealth to her during his lifetime because she told him that the costs of his care were depleting her own resources, and that was entirely untrue. And so the combination of the husband's cognitive decline, his dementia, and her influence deprived the husband of really appreciating his financial position, and the will was not really his own intended gifts. And so undue influence was also proven in that case. Speaking about litigation risks now in these circumstances, of course, if there are these issues that arise, you're going to face court applications and a trial to prove the validity or enforceability of the will. We call that proving the will in solemn form here in Alberta. And it can involve a full trial with respect to the making of the will. Of course, that is very expensive. And the legal costs may ultimately be borne either by the challenger if the challenge is not valid, or potentially the estate if the challenge is determined to be reasonable or warranted in the circumstances. But either way, we're talking about depleting a significant amount of assets of the people involved in the challenge or the estate itself. And, you're really risking significant legal fees on these challenges. So far better to address these issues early and get capacity assessments and so forth. Of course, these challenges would significantly delay the distribution of the estate and create a situation where family relationships may be permanently damaged as a result of the challenge to the will or the claim of undue influence. To avoid this kind of litigation, when there is some doubt about capacity, a capacity assessment is the way to go. You really want something that the court can take comfort in from somebody reputable, that they evaluated the person and determined that they were capable of making a will. With respect to family members, applying pressure to the person making the will to give a gift this way or that way, or draw your will this way or that way, is simply inappropriate. The person needs to make their own decision and follow their own heart in terms of the gifts in the will. To avoid that, if you feel as though there is a family member who is engaging in that kind of pressure or bullying, raising the risk of undue influence openly with them, so that they understand that what they're doing may put the will at risk, and taking other steps, if possible, to remove the testator from exposure to that person who is trying to influence the outcome of the will, are your primary methods of trying to avoid undue influence. I'm now going to speak about the third mistake in our list of mistakes, and that is unfair distribution. And I will speak to the jurisdictions other than BC, the common law jurisdictions other than BC generally, focusing on Alberta and Ontario. And Eric will then address British Columbia, which has its own special regime. So first of all of us have, under the law, a duty to support certain of our family members. Each Canadian province has its own laws relating to these duties. Of course, the examples we'll be addressing here are primarily Ontario and Alberta, and then British Columbia, as I've mentioned, but each province in Canada has similar legislation. There are minor variances between the provinces, and so advice would be required depending on which province you live in. Under the Ontario Succession Law Reform Act, there is clauses dealing with the support of dependents. In Alberta, that is dealt with in our legislation similarly. And those clauses provide that where a deceased has not made adequate provision for the proper support of their dependents, the court can order that provision be made. And effectively what it is if you do not make provision for your dependents in your will, then the court will supersede what you've said in your will and make an order that provides for those dependents. The question of who are your dependents is an interesting one and does vary somewhat between the provinces. Your dependents are narrowly defined. In Ontario, it's your spouse, could be parents, your children, or your siblings. And these people have to be dependent on you. So typically in the case of children, it's going to be minor children, can be children above the age of 18 if they remain dependent, depending on their schooling or if they suffer from a disability. The difference in Alberta that differs from Ontario somewhat in that grandchildren are listed as dependents under our legislation. The other interesting point is that spouses of course, can include now common law spouses, and each province has their own mechanism of defining what a common law spouse is under the legislation. Grandchildren in Alberta would be dependent on you if you have taken on the role of providing support or effectively parenting those grandchildren, as can happen in some family situations. Where someone does qualify as dependent, the court has to look at the adequacy of what has been done for them in the will. The assessment can include both legal and moral obligations in most jurisdictions, and the size of your estate is relevant. Of course, there can be competing claims by dependents, and so the court would have to weigh the claims of all dependents in arriving at an assessment both of whether the will did sufficient provision for those dependents, and if not, then considering what type of order might be required to provide for those dependents. Adequate provision, of course, is not some minimum standard to allow them to live, but is a standard that allows them to live in keeping with the lifestyle that the size of the estate and the previous living circumstances indicate. Where there hasn't been adequate provision in the will, there are many remedies that courts can choose from. It's not just, a gift of cash assets. There may be homes involved. There may be money payable from the estate on a regular basis until, say, a child has completed school, for example. That kind of thing. There is a broad variety of remedies. And the orders here are discretionary. Understandably, they're not an exact science. They need to meet the circumstances of the dependent and the estate, and so they can be very flexible. In order to minimize the risk of an application for dependent support, the testator needs to consider the potential claims that would be made against the estate of all those who qualify as dependents. The courts look at various factors in considering the amount and duration of support for these dependents and whether the will has considered those dependents and made sufficient provision. Of course, there may be provision that's been made for the dependents outside of the will, and that would also be taken into account by the court when assessing the provision made in the will. As Eric has mentioned, a statement of the reasons for the dispositions under the will is very helpful. That allows the court to understand the testator's thinking, also provides for an understanding of what other provisions may have been made or what other support mechanisms are in place for that dependent. And so these things are a helpful means of avoiding or minimizing the risk of a claim for dependent support. And with that, I'll turn matters back to Eric to speak about the situation in British Columbia.
Thank you, Alex. The most important difference between British Columbia and the jurisdictions that Alex has spoken to is that in British Columbia, there are a smaller group of dependents who can make a claim. But importantly, independent adult children have an ability to vary the will. So Nova Scotia has got a somewhat similar provision in its Wills Act, but in British Columbia, it is a provision which results in untold amounts of litigation, because in a sense, what the court can do is it can change or vary the will on the application or on the trial commenced by a disgruntled beneficiary. And so the important section to look at is Section 60 of the Wills, Estates and Succession Act of British Columbia, which says in so many words that despite any law enactment to the contrary, if a will maker dies and does not make adequate provision for the proper maintenance and support of his spouse or children, then the court may vary the will in a manner that it deems adequate, just, and equitable. And so that is somewhat unique in Canada and certainly in British Columbia leads to lots of litigation. Who would have standing to vary the will? That would be the spouse, both a legal spouse or a common law spouse. But under the definition of spouse or common law spouse in BC, you can have multiple spouses at the same time. So you could have several people making a claim. It would be children, either natural or adopted children, who have the ability to make this type of claim. But stepchildren and in loco parentis type of children would not have the ability to apply for will's variation. The seminal decision out of the Supreme Court of Canada stated that the test is whether or not the will makes adequate provision for the proper maintenance and support of the applicant. And then if it does not, the court may order what it is just, adequate, and equitable. So testamentary autonomy, the will maker's ability to deal with their assets any which way that they choose, that is deferred to by the court only after the will maker has met their legal and or their moral obligations. So how do you minimize the risk of such a claim materializing? Well, the first thing is you should make proper provision for your spouse and children, considering the size of your estate. The bigger the estate, the more likely the court will require that you make some form of provision for your children, even if they are adults, even if they are independent. If there's a small estate, a long-standing marriage, and you leave everything to the spouse and nothing to adult independent children, chances are a court may say, well, there's not enough money there to provide for the children as well as the spouse. As far as avoiding will's variation between children is concerned, treat them equally as much as possible, because if you don't, you're inviting a lawsuit because Bob is unhappy that Stacy got more than Bob did. If you do choose to disinherit, you need to have valid and rational reasons for doing so. And ideally, you prepare a memorandum or a statutory declaration explaining these valid and rational reasons, which have to be valid and rational at the time of your death. One reason that you could use to disinherit a child, for example, is this: if there's been an estrangement brought on by the child which has persisted for many years. But if there is, between the making of the will and your death, a reconciliation, and that is no longer a valid and rational reason as at the time of death, then the court likely will step in and vary the will. And then you should also consider some of the alternative planning options that I alluded to earlier on, and that Alex is going to touch upon, one of which can be a mistake if improperly applied, but certainly is one of the options available to you.
Thank you, Eric. Mistake number 4 is joint ownership. This can lead of accounts. This can lead to poor outcomes. It is generally a healthy option to consider in estate planning. Many people do make one of their children a joint account holder on their bank or investment accounts. And as lawyers, we don't shy away from that in the right circumstances. But it does take some careful thought and consideration as to who you might ask, who amongst your children or loved ones you might ask to become a joint account holder with you. It does also create some issues down the road once you've passed, because the question of intent in making your child, for example, a joint account holder with you becomes a live question upon your death. And that is, in most joint account agreements with banks and so forth, the account passes to the survivor upon the death of one or the other of the joint account holders. Now, the question becomes, was only legal title to pass, or legal and beneficial? In other words, was it intended that the child would receive the benefit, the gift, effectively, of the assets in that joint account when the parent passed? The law provides that there is a rebuttable presumption that there is not a gift intended when an aging adult puts assets into a joint account with an adult child, or puts the adult child on that account as a joint account holder. The law presumes that what was intended was that this was done for ease of administration, because as you age, you may not be able to keep up with some of the duties, paying your bills, attending to your investments, and you've asked a child to help, and this makes that smoother. Not only that, you may want to put the child on your joint account in order to take those assets out of the need for probate. The need to put through probate. But the law says that it is presumed that that is not meant to be a gift of those assets upon your death, and rather that the child owns only as a trustee. So that difference, of course, there is a difference between spouses or from a parent to a minor child. The law in that situation contains a rebuttable presumption that there is a gift. And so you need to be aware of those presumptions and account for them. And that can be done with a written declaration as to your intent. And so that's one means of avoiding that dispute. With respect to examples, the Our Estate case involves a mother who had two daughters. They were both trustees of her estate, but the mother, prior to her death, had put her accounts in joint names with one of the daughters. That daughter, upon the mother's death, claimed that the joint accounts were meant to be hers, because when she became the survivor of those accounts, she claimed that the mother had intended that she would have those assets outright, not only as trustee. The daughter pointed to the signature cards opening or transferring the account into joint ownership, the agreement with the bank, services and help that she'd provided to her parents, and the fact that the joint accounts were not mentioned specifically in the will. In this case, the court held that that evidence was insufficient to rebut the presumption that there was no intent to transfer the beneficial title in those assets to the daughter. That, of course, the bank agreements typically do say that the survivor receives the assets, but that is not necessarily meant to be a gift. And of course, we've all seen the forms of bank agreements. If any of you have the patience to read them each time, you're more patient than the normal person. So, it's unlikely that the deceased actually went through and read and turned her mind to this issue of survivorship. That seemed very doubtful to the court. And so the conclusion was that the survivorship indicated in the banking documents was just not enough to get to the court to conclude that there had been an intent to transfer the beneficial ownership of the assets in those accounts to the one daughter. So if the intent is, in fact, to make that transfer, much clearer documentation would be required and should be put in place in order to make that intent clear. So how do we address this if that is the intent? And sometimes there is an intent to gift one daughter because of substantial services provided during the parent's lifetime, or one child, I should say. And if that is actually intended, there should be some express statement to that. Probably best to do that either in the will or in documentation prepared at the time of the will to explain why that is being done. And of course, if you are entering into a joint account with one of your children and you don't intend to gift the child the beneficial interest in the account, that can be made clear as well. The other option, and there are other risks to joint accounts, and so the other option is to use a power of attorney rather than the joint account scenario to address the useful services that one of the children can provide with respect to handling financial matters. And the other risks with joint accounts are, you definitely want to choose a child that is financially comfortable and responsible, and there's very little risk of themselves going bankrupt or running into financial trouble, because if the assets or the account is in their name, creditors may look to that asset to try and recover. And of course, you want to choose a child that has the ability to be objective, that isn't in a dispute with their siblings or doesn't have some axe to grind with them, that you expect them to behave objectively and in accordance with your wishes. I'll turn this back to Eric now for the next section.
Thank you, Alex. The next mistake I'm going to identify or have identified is picking the wrong executor or trustee. You heard Alex mention you want to be picking, when you're doing the joint tenancy planning, a child that doesn't have an axe to grind, somebody who's not likely to cause ripples within the family. The same thing is true for the executor that you choose. And so an executor is the person that you nominate when you make a will, who is going to administer your estate. They're essentially going to gather all your assets, they're going to liquidate all your assets, and they're going to distribute the estate as per the instructions in the will. And as such, that person is a fiduciary. They have an obligation to distribute the estate in the exact manner in which the will prescribes. They have, however, got access to all the estate assets, and they have a significant responsibility. And as a result of that, if you pick the wrong person, it's very likely that one of the beneficiaries may say, hey, this is not somebody to be trusted, or this is not someone who's up to the challenge, and that may cause fractures that may result in some form of litigation, which I will address shortly. The most important thing to know about choosing an executor is that your family members, as much as they are well-intentioned, are not necessarily always suitable. There can be conflicts between siblings, there can be conflicts between children from a prior marriage and the spouse in the blended family context that we see so often these days. If you choose two of your children to have the one keep an eye on what the other is doing, that joint appointment can result in a deadlock, which means the estate can't be administered because, generally speaking, both executors need to be acting unanimously. You could be picking somebody who doesn't necessarily have the skill sets or the knowledge to be able to efficiently and effectively run the estate and administer it. And then when you're picking someone, oftentimes spouses will appoint each other, makes sense. But what if your spouse is the same age as you and therefore likely to pass away? Age may be a factor also when it comes to capacity or their ability or inclination to want to administer the estate. If you pick a non-resident executor, someone who is from out of the province, that can present its own set of problems because they may not be able to get a grant of probate, which is the document the court issues to the executor to be able to deal with third parties such as the Land Title Office or banks. They won't be able to get that grant of probate without first posting a bond or getting a waiver from the court. And a US executor or an executor who lives out of the country is potentially raising residency issues of the estate, which can have tax implications to the executor and to the estate and should be avoided. So when you pick an executor, it should be someone who is based in British Columbia or in whatever province you're living in and die at the time of your death, because that just makes the administration of the estate a whole lot less likely to be contentious and difficult. What if you choose poorly? If you choose poorly and you pick one of your children that has an axe to grind, or where other children have an axe to grind with them, or you pick someone who is on their face potentially a problem, then the first thing that's probably going to happen is that one of the beneficiaries will file a notice of dispute or an objection, depending on the jurisdiction. They have different names. That holds up the administration in that you're not able to obtain a grant of probate until that dispute has been resolved. And it can also, if you pick the wrong person, result in an application to remove or pass over the executor or trustee. The two are the same, except they appear in different sequences. You apply to remove an executor who already has a grant of probate, and you apply to pass over a named executor before they get their grant of probate from the court. But the net process is the same. Someone is going to say, this person is not suited to be the executor, should be removed or passed over, and somebody else should be appointed in their stead. The litigation costs of this kind of application can be extremely high because each of the beneficiaries under the will has the entitlement to their own legal representation. So too the executor or trustee that you're looking to remove. And so you might have 5 people, each with independent legal advice, each with their own lawyers, and each of these lawyers is going to get paid. And oftentimes the court will order that the costs are paid from the estate. So you've worked your whole life to make your estate or to build wealth. You really don't want to be having your estate spend that on lawyers because you chose the wrong executor. The practical the practical effect of a badly chosen executor is that while there is a dispute or an objection ongoing, or an application to pass over an executor is ongoing, there ought or generally would not be somebody to administer your estate, which means everything gets held in abeyance. That can take years to resolve. And it can also result in the fact that maybe taxes aren't being paid or filed. There are issues with regards to renewing a mortgage, for example. And another option is that an administrator pending litigation or pendente lite may be required while this dispute about the chosen executor gets resolved. That adds additional cost, that adds additional delay, and that is going to hold up your estate, and your beneficiaries won't get anything for a while. So how do you avoid that? How do you prevent as much as possible? Because you can never really have an ironclad policy in place, but how do you try and minimize your risk? Only nominate somebody who is capable, right? Only nominate someone who you think is not going to cause fractions within the family, someone who is able to actually take on this task. It's got to be someone you trust implicitly because they have this fiduciary role. They have access to all of your money. They have access to all of your assets. And the only way to keep the beneficiaries from challenging that appointment is to ensure that it is someone that they can also trust, where they're not concerned about what the executor is doing. So in that case, avoid children or family members where you think a conflict may arise. If you think that there could be an issue between appointing one of your children as opposed to the other, then avoid both of them because it's inevitably going to result in some form of tension. And even if no court application is brought, it may very well fracture the relationship between the siblings. If you do decide to have more than one executor, which you can do, then consider having a tiebreaker in your will. In other words, some form of provision which allows for a resolution of a deadlock. And the easiest way is having 3 executors and a majority rules, right? But if you're concerned about the executors keeping an eye on each other and making sure that nobody's doing anything wrong, you're already picking the wrong person. You should always consider arm's length executors or trustees. There could be an accountant, it can be a lawyer, or it could be an independent trust company. You're not going to avoid your chosen executor having the entitlement under the trustee acts of the various jurisdictions across Canada from charging a fee for the administration of the estate. They're going to charge a fee in all likelihood. So whether or not you're appointing a professional or you're appointing a family member, the estate is going to have that expense. But the benefit of an accountant or lawyer is they're independent. The same with the trustee or the trust company, which are statutorily regulated. They're professional, they have insurance, and they're very competitive when it comes to their pricing. So those are just some of the ways in which you can avoid picking the wrong executor. And so with that, I will turn over to John for his discussion on pour-over clauses.
So I'm going to try to move through this section quickly. It's a rather esoteric area, but it has come up in recent litigation in BC and Ontario as to what they are and why they're ineffective. But this does fit under the heading, the first heading, which is do-it-yourself wills, except I'd say expand it. This is also having someone prepare your will who is not a wills solicitor. So that excludes Eric, Alex, and me, because we do litigation. We just see the problems at the end. So just going to the next slide, there's a number of headings here. The first one, what are pour-over clauses? I'll come to that in a second. The U.S. experience on them where they have been permitted, that's because of legislative changes. So other than pointing out that they've had to fix it up through legislation there, and we don't have it here, I won't spend much time on that. And then we'll look at some of the experience in BC, touch on Nova Scotia where they may be permitted, and Ontario, which has followed BC in not permitting pour-over clauses, which answers bullet point number 4. Should they be used? No. So what are they? First of all, we'll look at the next slide. It's a provision in a will that directs that the residue of the estate doesn't go into a normal trust under a will. All wills create trusts. In fact, when people talk about the executor, normally you appoint an executor and a trustee. Typically, it's the same person or group of people, but it doesn't have to be the same. But the trust deals with the distribution of the assets. What this is directed at is where you've already got an existing trust, and you simply say, my trustee under the existing trust will make my testamentary disposition. I'm not going to make it. In effect, they will decide for me. And there's a number of problems with that. And we'll just go over to the next slide. Oh, actually, we're not going to go in the U.S. experience. We'll just go over the policy considerations. So it's the next slide. I'll just touch on it briefly. It doesn't meet the formalities that a will necessarily requires, because they're different for setting up what's known as an inter vivos trust. That's a trust while you're alive. And a will, and then there's a whole host of other issues. There may be cost savings initially, but not ultimately, because there will be a challenge. Is there flexibility? Yes, because you're saying somebody else can decide, but that's really, I suppose, in the eye of the beholder, whether you consider that flexibility or just confusion. You can avoid, you don't get the benefit of certain tax benefits that you can get through estate planning. Certainly, you don't get certainty, to be redundant, under the will, because you've given the testamentary decision over to another person. And then over on the next page, I'll just touch on the privacy one. A will is confidential until the deceased dies, with exception. There's some suggestion that where the individual has irrevocably lost capacity, that perhaps the will can be accessed before death, but that's an area not for today's topic. But an inter vivos trust isn't necessarily private and confidential. And the other problem you run into is you have people lobbying the trustee to exercise their discretion post-death pre-death, but in respect of a post-death disposition to distribute the assets. So for a host of policy reasons, the pour-over clauses don't pass muster. In British Columbia, just going over to the next slide. The next substantive slide. Yeah, this is the 2013 decision. And you'll see the second bullet point there, that a trust incorporated by reference into a will, so that would be an existing trust, an inter vivos trust, is valid only if it exists at the time of the will's execution, is clearly identified, and without future amendment. So if you put all the property in at that time into the inter vivos trust, and the trustee can dispose of it, that's fine. But you can't have the trustee just with an open discretion to dispose of the property after death. I'll go over I'm going to skip one slide in the interest of time and go over to, it's actually a few slides over. It's the Mio case, because it's a 2025 decision in Ontario. So what had happened in Ontario in earlier cases that had followed the BC line of cases, not upholding pour-over clauses. And one of the criticisms concerning pour-over clauses is that they did not meet the formalities that a will required. But in Ontario in 2022, there were legislative changes relaxing or giving the court the ability to relax the formalities for a will, certain formalities. And so an attempt was made to enforce a pour-over clause on the basis that the formalities for making a will had been relaxed. So these pour-over clauses into intra-vivos trust should be permitted. And the court did not allow that argument. Said, look, there's a difference between not complying with the formalities and not complying with the substantive rules with respect to making wills. That is to say, as set out in the note here, that the legislative changes in Ontario can cure, in the discretion of the court, technical problems, but not substantive legal problems. And the pour-over clause has a substantive legal problem. So going to the next page, and I'll just finish on this slide because I know we have some good questions and I want to get to them. There's just a summary here of where these pour-over clauses have been declared invalid, sometimes valid, and valid. I'm not aware of any legislative changes that are proposed in the meantime in Ontario or BC to move to the statutory acceptance that they have in the US, but you never know. Sometimes we lag behind on these things. So with that in mind, and sorry I had to move through that quickly, but as I say, it is a rather esoteric area. I'm just going to come to some of the questions that have been provided to us, and thank you for those. One of them is, in respect of wills, are there, and the wills types of problems we've been discussing, are there any pitfalls for business families in particular? The short answer is yes, and I'll leave it to Alex and or Eric to expand on why.
Why don't I start to address that? So with respect to business families, families who have an operating business, there are complications there. Are some of your children involved in the business? How do the other children feel about that? Again, this can create some family tension. With respect to operating businesses within the family, there are other considerations that should be considered, such as an estate freeze earlier on in the process. You may consider a family trust, an alter ego trust, and so those sorts of things should be canvassed. There may be some tax advantages to the structure of your estate and the use of some of those trusts that I've mentioned. But an operating family business definitely complicates an estate plan, and an experienced lawyer is really very useful to speak to in regards to those situations.
Yeah, and I don't really have much to add to that. I think that the more complicated your estate is, the more involved or complex your businesses might be, or your business might be, the more necessary it is for you to meet with the right estate planning lawyer, because a simple will in those circumstances won't cut it.
And just touching or expanding on that, Eric, one of the other questions is what happens when there are properties abroad, and perhaps our discussion today on do-it-yourself wills is particularly applicable to concerns that arise in that respect. So maybe you can address that.
Yeah, so if you have a grant of probate, so probate essentially follows domicile. So where the person is domiciled or ordinarily lives and considers to be their home at the time of death, that's where a probate is going to be issued. So the grant that you get, let's say in British Columbia, is not necessarily going to be effective in other countries. You would potentially have to go through a process to reseal the grant in those jurisdictions, which will be additional costs. You would have the option of making a specific will for a different jurisdiction if you have property outside of Canada or outside of your jurisdiction of choice. But it's just one more example of, if you don't know that there are these risks, if you haven't been advised as to your options as to minimizing risk and being efficient, it may end up costing your estate a lot of money. There's an old saying amongst estate planning lawyers, which is you can pay us now ahead of time, or you're going to pay us down the road, or your estate is at least, when we try and fix the issues that could have been addressed ahead of time. But one way or another, you're going to pay. So I think that it's much more inexpensive to do this ahead of time, to get the right advice ahead of time, than it is to see what happens. And then once you've passed away, it really becomes the issue that your beneficiaries have to deal with.
Thank you. So one of the other issues is perhaps obvious from the presentation. What planning should you do for children or adults with special needs? It's obvious, just to answer the question that's been put. It's a fair question. You can't do that through a do-it-yourself arrangement. It's just much too complex. One of the other questions that's been put is, are there guidelines around compensation which an executor can or should draw from an estate? And yes, there are, but perhaps Eric or Alex, you can address that in the context of the do-it-yourself scenario.
I'm happy to take that, Eric. Yeah.
Sure, I'm happy to speak to that. So each province has its own scheme, its own trustee act. But speaking for British Columbia, you as the executor or the administrator of an estate would have an entitlement to 3 different types of compensation. The first is a capital fee, which is up to 5% of the value of the estate assets that the executor is entitled to claim. The executor is also entitled to an income fee, which is up to 5% of the income that the estate earns from the date of death until the date of distribution. And then the third is up to 0.4% per annum for a care and management fee, which is essentially in addition to the other 2 fees, saying that, well, because you have the risk as the executor trustee, you have liabilities potentially where you're administering an estate and you're managing it, you're entitled to those fees. So those fees can be in addition to each other. They can also be alongside each other. It really depends on the complexity of the assets under administration, the length of the estate administration, the difficulty of maximizing the estate's assets and value, and the success that the executor has had. But those are the prescribed amounts that your executor could receive. It's not necessarily so that they're going to get the maximum. They would have to justify that, but that is the maximum that they could receive. You can, of course, in your will, set out what compensation, if any, the executor will be entitled to. And you'll find that when you negotiate terms with a professional trust company or a professional accountant or a lawyer who you're going to be appointing as an executor, you do that ahead of time when you're making the will, and you can negotiate terms with them, which would be less than the maximum prescribed by the Trustee Act. But you have that ability, you just need to know about it, and you need to know that if you don't make specific provision for what the executor can claim, then the Trustee Act will govern.
Thank you. I see that we've come to the end of our time for today. There are lots of good questions. I'm sorry we can only touch on a few of them. We've put up on the screen the CPT credits for Ontario, BC, and British Columbia. And then if you don't get your chance to claim your certificate today, they will be sent next week. There are 2 more webinar presentations in the series. One is on October 16th. The topic is Undue Influence Over the Vulnerable, Protecting Against and Preventing Coerced Estate Plans. And that might be of assistance to one of the questions we had here. In terms of how do you protect against those circumstances. And the next one is on November 20, and the topic is Beyond the Will, Managing Dependent Claims, Modern Family Dynamics, and Unexpected Heirs. And so you can find the link for these events in the chat, and we look forward to seeing you at our next sessions. Thank you very much.